Welcome to RPGPTV, another episode where we talk about everything property. This is Rawson Properties Grassy Park, also known as the Yellow Machine, and today I'm super excited because we've got a really important guest. Welcome to Rahima Esack from Esack and Mulder Inc, conveyancer and notary in Kenilworth.
It's a pleasure to be here, and I'm glad I could help.
Trust me, the pleasure is all ours. Welcome Jerome Hendricks, franchise manager, Rawson Properties Grassy Park, and Roxanne Krauster, franchisee, Rawson Properties Grassy Park. Welcome to both of you again. We want to educate our audience about everything property. And I think it's super important that we have a conveyancer here to talk to us about that process after the sale takes place, because it's still a long process. Jerome alluded to in one of our very first episodes that the hard work actually starts after the documents are signed. That process generally takes around 2, 3, sometimes even 4 months, sometimes even longer. We really want our audience to know what happens thereafter, what they need to look out for. So I know that's a broad question. Maybe we could start with, when you receive that offer to purchase from the agency, the estate agent, what are the next steps, please?
So the very, very first thing that we do when we receive that offer to purchase is check for suspensive conditions. We also look at what the information that we've received from the agent relating to the seller and purchaser, and how that compares to the information that the deeds office may have with regard to those persons or companies or entities.
Now tell me, what are suspensive conditions for our audience at home that doesn't know what that is?
A suspensive condition is a condition that, as the name suggests, suspends the sale until that condition has been fulfilled. So typically it would be the bond approval clause, because the sale would be subject to a bond in favor of the purchaser being approved for a certain amount by a certain date. And if that doesn't happen by that certain date or for the amount that should be approved, then the sale simply lapses. So every suspensive condition is going to have those words subject to. If it does not have those conditions, then we refer to that as a special condition. So for example, a suspensive condition would be a bond approval application. A special condition could be something like a purchaser saying, I would like to purchase this property, but the seller must paint the exterior of the property by a certain date. That's not a suspensive condition, because it doesn't say, I won't buy this property if the seller doesn't paint the outside of the property. It simply says that the seller needs to do that by a certain date, and the words subject to aren't part of that condition.
Now, I'm sure, thank you for that, very interesting. I'm sure we've had customers, or you've had customers, Jerome, or even Roxanne, who's WhatsApped you throughout that process to find out when is it going to take place. And I'm sure key words come up when you talk to them. It's jargon for them. They don't understand it. We understand it. But let's make our audience smarter. So what does lodging mean? Or we've got to wait until it lodges, etc.
Yeah, I think I had a client actually this morning that was quite concerned about that. So sellers have a time frame in their mind as to how long a bond takes to be approved. Generally, am I right in saying about 5 to 10 days? Just approval, and if they don't get that, they get very anxious because the suspensive condition is taking very long.
Correct. So it does generally take about that time, but it depends on whether the purchaser has provided all the information the bank needs to make an informed decision about whether this person can qualify for the bond. The second part of that process is that the bank needs to find value in that property. So because that property is going to be the bank security for this large amount of money that they're loaning to this purchaser, they need to make sure that if anything goes wrong, if they sell that property, will they get their value back?
Correct.
So those are the things that people don't consider, because they think, oh, I've given all the information to the property practitioner, everything is fine. But the bank may have questions after that, especially people who are self-employed. They need to have their financial statements of either themselves or the company. They need to show that they have a certain income every month and that it's stable. They also need to have a good credit score.
I just want to ask about the special condition that you mentioned, which is very important. The suspensive suspends the sale until that's met. The special condition is just a term given to something that must be completed before registration. What happens if that is not completed? What happens if I didn't paint the house?
Then I cannot register that property.
Okay, so it is a problem with registration if those special conditions are not met.
100%. So before registration can take place, I will contact the seller if there are special conditions. Actually, even before registration, because I like to make sure things are done before that. Before I send that transaction to the deeds office, the seller needs to confirm to me in writing that that house has been painted, or whatever else, whatever the other conditions are.
And I think, to your point, you've even contacted us as the agent to do that inspection.
Correct.
To find out that those things were done.
Yes.
Okay, super.
I just want to clarify something for the benefit of our audience. You might see these job titles touted about on social media a lot, but property practitioner, real estate agent, sales partner, they all mean the same thing. So just to give you some context in the audience, because I know, Raima, you alluded to property practitioner earlier, and in a previous episode on RPGPTV, I alluded to sales partner when speaking to a gentleman by the name of Theo Snitcher. So a bit of insight for you there, audience. Now, voetstuts is an old term that comes on donkey years. What does that mean?
Okay, so it comes from our Roman Dutch heritage, because South African law is a combination of Roman Dutch, English, and then we've added our own spin to things after 1994. So voetstuts basically means that the property sold as is. Okay. But what that doesn't mean is that if there are problems with the electrical wiring of the house, for example, if you're selling a house, or the plumbing issues,
The pool pump.
anything like, yes, those things, they will be dealt with in the certificates of compliance. And with every property that's sold, there need to be certain certificates of compliance issued to confirm that the minimum safety standards have been met. So if, for example, there's a pool pump that needs to be fixed and that forms part of the compliance, the certificate cannot be issued until that repair work has been done. And sellers need to understand that, because they think I'm selling the property as is, so I'm not going to have to pay for anything relating to this transaction.
I must confess, I was one of those sellers, Roxanne and I. We had a property in Plumstead. We sold it voetstuts, but after careful inspection, they saw that the pool's water levels were dropping considerably or unusually faster than normal. And then later on found there was a defect in the pool pump, etc. So we had to fork out some money to repair that first before we could take ownership.
Yeah.
Super. I wanted to ask about your voetstuts. What about the latent and patent knowledge of defects? So there are sometimes defects that the seller is knowledgeable about and doesn't declare.
Yes.
And hopes it's summertime, it's no rain, so nothing's going to get exposed. And it comes out later. Or there's others that he really doesn't know. You know, I had a property in Surrey Estate, old property, about 70 years old, had a carpet in the lounge. The new owner wanted to lift up the carpet in tile, and when he lifted it up, he found that there was little wooden towels, and when he lifted that, there was a huge crack in the foundation. And that crack would only have been found once you took the carpet away. But that carpet was there 20 years. So the seller didn't know there was a crack. But how do we deal with latent and patent defects?
So let's look at what a latent and patent defect is first. So a latent defect is something that I can't see. So exactly your example, that's something the seller did not know about, because the carpet was over there, the tiles was over there. There was no way for them to have known that that crack in the foundation existed. So that's a latent defect. Patent defects are defects where I can clearly see it with my eyes. So if there is a crack in a wall, for example, and there's no curtain covering that part of the wall, or there's a broken window, or I see the front gate of the property isn't opening and closing properly, that's a patent defect. It's something I can clearly see. So the seller has a responsibility in terms of the Property Practitioners Act to to disclose whatever defects they are aware of in something called the mandatory disclosure document. And that document forms part of the offer to purchase. The seller will typically fill this document in at the start of the process when they're filling in the mandate with the agent. And any potential purchasers who wish to submit an offer must be handed a copy of that disclosure document. And they need to sign it so that they are informed, they can make an informed decision about whether this is a property I'm willing to accept with these defects that the seller has disclosed. In terms of our law, a seller won't be liable for latent defects because it's not something that they would have known about. But the seller could be held liable for patent defects.
Yeah, I actually was trying to stress the point is not just what you can see, but it's what you know. So if you got a curtain covering a crack and you know there's a crack behind the curtain, you can't say I didn't see it.
That's right.
If you know it exists, you need to declare it.
Yes.
Okay.
And that normally gets declared on the
mandate stage, at the mandatory disclosure property report, 100% there. And we've had issues with that before where when buyers go through that to sign, they actually review their offer. Because there are quite a few things that they didn't fully understand or wasn't disclosed, that they couldn't see, but when made aware of them in the report, they said, well, I'm not putting an offer for 2 million, I'll put an offer for 1.9. And it's because of that knowledge. Yes. The other part of it is, on that disclosure report, the seller can make known if he's going to repair those. He knows that there's those defects, if he's going to fix them or if he's selling it still as is. And if you accept that as a buyer, then you accept that responsibility.
100%.
Sounds good.
I just want to add also that sellers shouldn't feel that they shouldn't make those disclosures because now potential purchasers are going to offer less because of the known defects. Sometimes if you don't disclose, well actually most times, if people do not disclose the defects and it's discovered at a later stage and that results in litigation or court action being taken against them for not disclosing a defect that they were aware of, it could end up costing them far more than that.
I think you said that they obviously doesn't necessarily mean it's going to go for less.
Yes.
It rather disclose everything, say what you're going to repair and what you're not going to repair, and they can make a true assessment as to the price.
Yeah. There'll always be a purchaser who may be willing to accept the property with all those defects and pay the purchase price.
Yes.
Most times they are.
Yes.
Yeah. No, that makes sense. Yeah. Absolutely. So now, Esack and Mulder Incorporated, conveyancer and notary, yourself. You are one of our legal partners at Rawson Properties Grassy Park. When a seller decides to sell with us and we find them a buyer, as we've done in the past, we put them in touch with Rahima. There are transfer costs and registration costs that the seller needs to
that the purchaser will obviously transfer costs.
Talk to us about that.
Okay. Also, an important thing to remember is that people often forget that there are bond registration costs as well. So if you are financing the property by means of a bond, there are two transactions. There's the registration of the transfer and the registration of the bond. And those are two separate transactions. And depending on who the bank instructs to register that transfer, the attorney who does that registration, even if it's the same firm as the transferring attorney, it will still be two separate costs because it's two separate transactions.
Okay.
So that's another thing to just bear in mind for potential purchasers.
So then just talk to us again about the difference between the transfer duty and the transfer costs, please.
Okay. So transfer costs are the attorney's fees. Transfer duty is the tax that the purchaser will pay when they acquire a property when the value or the purchase price is more than 1.2 million rand.
Got you. Perfect.
So there won't always be transfer duty applicable, but there will also always be transfer costs applicable.
So I've seen that before. There's an invoice that gets sent to the purchaser.
Correct.
Who sends that out? Is it
The attorney,
right?
yes.
So you would send that out to our purchaser.
That's right.
So those numbers are slightly different sometimes. They don't always match. You get a transfer cost, that's the cost of the property. So if the property is 2 million rand, you're transferring 2 million, that's the cost of the transfer. The bond cost can be 1 million because you put a deposit in and then the cost of that is on 1 million. Both of those are for the buyer. The seller has completely different cost. The seller's costs are more about compliance, rates clearance, and
possibly levies in the case of a sectional title property.
100%.
but those are generally the costs. I think it's rates clearance and levies or compliance certificates.
That's right, yes.
Okay.
Just explain to our audience the difference between a freehold property and a sectional title.
Okay, so every piece of land in South Africa is registered in a land register at the deeds office. We have one of the most secure land registration processes in the world.
Wow.
So that's one thing we can brag about in South Africa.
Brilliant.
If I want to know who the owner of a certain property is,
Yes.
anywhere in the country, I can contact the deeds office and they will give me that information because it is public information.
Yeah.
They won't disclose the details of the person,
course.
but they will simply be able to tell us who the owner is. So there are different land registers. There's one for freehold property, and we call those urban. The singular is an earth, and then properties that have been converted from an earth into a sectional title scheme gets put on a separate land register, and that's the sectional title schemes register. And once property has been converted from an earth to a sectional title scheme, it no longer forms part of the earth land register, it goes to the sectional title land register. And from that moment on, it doesn't have an earth number, it's described with reference to the sectional title scheme. It's known as a unit, we call it a flat. There could be exclusive use areas linked to that, but it's not an earth anymore.
How long have you been in this industry?
In March, it will be 20 years.
Wow.
Almost as old as I am. we wish.
Why is it important? And our audience, they're watching, they're listening, for our audience to choose the right agency who is partnered with the right conveyancer.
I was hoping you would ask that question because I've heard of so many horror stories. You need an agent that you can trust who is upfront about information. If someone is not willing to give you the information that you have requested, obviously respecting people's privacy, but if it's something that's not unreasonable that they could provide and they're not giving that to you, that is red flag number one. Also, another thing to look out for is if people don't respond to your telephone calls or your messages. If someone is serious about ensuring that the transaction is concluded in the right way, they'll deal with you in a professional manner. And the minute you see signs of that, it's not a good sign.
Absolutely.
So having the right people attend to your transaction is extremely important. And partnering with people who you know, if I contact this person today, they will give me the honest answer. And they will be able to explain how this process works to me. They won't have any issues in explaining it once or twice or 3 times, however many times I need to go through this. They will sit there and assist me in this process. Those are the types of people that you need to work with.
Yeah, I want to add to that, and I think we pride ourselves on, we don't stop when the deal is signed. When the paperwork is done and registered is when we stop. Because half the work is only done when you find a buyer. And the sale is done. But there's a whole host of legal documentation that you guys go through, that we partner with you and we walk through with the client every step of the way to make certain that we get to the end. One important question I want to ask you about is the FLISP. We spoke about suspensive conditions, and we spoke about one of them can be you need to apply for a state subsidy. I think we're well versed, and maybe you can touch on what do you need to qualify for a state subsidy, but also as a seller who previously had a state subsidy, what do we need to be aware of, and how upfront must they be with the agents when they know about that?
Okay. So I think I'm going to focus on the sellers, because the purchasers know more or less what they need, the information is out there. It's the sellers who previously had the subsidy that don't really have access to that information. So sellers or owners of property who were assisted by FLISP or government subsidies, similar government subsidies, will have 2 conditions in the title deed saying that they cannot sell that property without the consent of the Department of Human Settlements. It also says that if they do want to sell, they can only do so within 8 years of acquisition of that property. So if I had a FLISP subsidy when I purchased my property, there's a condition in that title deed saying I can't sell it within the first 8 years. And secondly, if I do, then I need the Department of Human Settlements to consent to that sale. So if someone is sitting with a situation like that and they are thinking of selling their property, they can only sell it to a South African citizen who has never owned property before. Because FLISP and these subsidies are granted to people who have never had homes before. It's part of our government's way of ensuring that they provide housing to those people who have never had housing before. So even if I inherited a property, it's not something I purchased, that will count as me owning property before. And FLISP, those government entities have ways and means beyond what we know. So even if that property that I owned 10 years ago that I inherited and I may have sold it, so it's not even registered on my name anymore, FLISP will pick that up and they'll say, but you own property, you can't purchase this property from this owner.
So I think it's very important that you mention that, because our sellers that were in that scheme needs to be upfront with that. Our agents need to ask for that, so that we don't get ourselves in a situation where we've thought we sold the property to somebody only to find it that is discounted later by human settlements. And I think it takes away all the mystery from that if we just deal with it up front properly.
But then the conveyancers also do that check as a safety net in the event that the seller did not disclose, that the agent potentially did not ask.
We find that most often sellers or owners of property don't read their title deeds. And if they do, they maybe read it when they purchased the property 10, 20 years ago, and they haven't looked at it again. So that condition is not in their immediate mind right now. They're thinking, oh no, we can sell, it's fine. 8 years have elapsed already. I don't need to worry about anything. But even if the 8 years have elapsed, we still need to remove those conditions from the title deed, because the new owner is not going to be subject to them. And there's also a process involved in that. So it's important for the seller and most definitely the attorney who is attending to the transaction to look into the conditions of title.
Just a question, you got me thinking now. So if a seller who previously was part of that scheme sells it to a first-time home buyer, South African, that also is requesting FLISP, does that go a further 8 years again?
That's 100%. Okay. So it starts from the moment the new owner becomes the owner of the property.
And just a question, Rema, if you are removing those conditions from the deed, is there a cost involved?
No, there is a cost involved from the attorney side, but from human settlement side there isn't. So they simply have to give us a consent to remove those conditions. If the 8-year period has elapsed, it's a simple document where they'll say, we hereby consent to it's a one-pager. But there is a time factor involved. Because it's a state that we are dealing with, we need to submit that application. They want supporting documents, which the attorneys will send to them, and then they'll tell us when we can collect the consent.
Okay.
Well, Raima, we've got a question from one of our audience members online. This person, he's living in the property currently. If they want him to inherit the property early, before they pass on, is that possible? What is that process like? And also, in most cases, there are people who come to us to sell a property because their parents are deceased or partners deceased, etc., etc. Talk to us about that process, please.
Okay, so deceased estates are a bit tricky because the master is involved in that process. They have to be.
And the masters is what and where?
The master is the state entity that oversees and administers and makes sure that the attorneys who are attending to the winding up of estates are doing things in accordance with the law.
Okay.
So everything that we do with regard to estates, once someone has passed on, must be okayed through the master's office, including the transfer of property from a will, in terms of a will, or if there wasn't a will, in terms of the Intestate Succession Act. So we often get that question where parents think, should I leave it to my son or daughter in the will, or should I just give it to them while I'm alive? So if you are simply going to give a property to your child while you are alive, then that will trigger donations tax from SARS. And that's 20% on the value of that property. And that's huge. That's a lot of tax to pay.
2 million rand property, 200,000 rand.
Yes.
That you're giving away to
for one
400, yeah,
for one property. So then they think, well, maybe we should put it in our will. But I don't want to actually deal with this property. I don't have the time, the energy, or the resources to maintain this property anymore. I want my son or my daughter to have it now.
Yeah.
And then I can just live in the property.
Yeah.
I wouldn't mind that. Then my advice to that parent would be to sell the property to the child at the market related value and register for themselves something called a usufruct. So a usufruct is a right that one person has over another person's property to the use and enjoyment of that property. It can be for their lifetime, it can be for 2 years, 5 years, whatever they decide. But most often when I'm dealing with these types of transactions, I will include a lifelong usufruct in favor of both parents so that they are protected for their lifetime. And what that means is that the son or daughter who purchases that property purchases certain rights in the property. So they don't enjoy the full use and enjoyment of the property because the parents have this usufruct over that property. And what that does is it ensures that the child cannot sell, cannot bond, cannot lease that property to anyone without the parents' consent. Yeah. So if the child decides to sell that property and the parents are fine with it because they'll be moving with the child to their new home, that's all in order. The parents need to then sign that offer to purchase as co-sellers in their capacities as the holders of the usufruct.
Gotcha.
And there are cost implications involved as with any other transaction. So when we register a usufruct in favor of a third party, for example, let's say that the property was in the name of a company that the parents owned, and now they want to transfer that property to their son during their lifetime. I would then suggest that we transfer the property to the child and register usufruct in favor of the parents. But the Deeds Office says, or the Deeds Office Act says, Deeds Registries Act, that when there is a usufruct in favor of a third party, we need to create that usufruct notarially. So that means there are notarial documents that need to be drafted and signed and registered simultaneously with that transfer. And of course, that's an added cost. Where the owner of the property were the parents themselves and not the company that they owned, then no such notarial costs arise, because then I can simply say that the usufruct is in favor of the previous owners and there's no need for an additional notarial deed.
Makes sense.
Yeah, I just want to say that this is becoming a common thing nowadays. I think historically people used to like leaving properties as an inheritance. Inheritance nowadays, the modern way of life is you almost do it while you're alive, so that there's no confusion about your wishes after you pass on. So a lot of people are actually wanting to instruct properties to be transferred to kids as part of an inheritance while they're alive, but then that usufruct becomes extremely important so that they're protected. The one thing that I just wanted to ask you, you said that you can only sell that house that has a usufruct on if you give permission. So now they do give permission because circumstances have changed and they buy a new house. That usufruct does not get transferred to the new house. You need to put a new usufruct there. So it's important just to caution our parents that it's good that we have a usufruct on that first property. If circumstances change and you need to sell, consent to it, but make certain your next property has that same usufruct instructed on the title deed.
Wow, great questions, Roxanne and Jerome, and expertly and insightfully answered. Rahima, thank you so much for attending or being here today and sharing your knowledge and insight and your wealth of experience with us. Well, there you have it, ladies and gentlemen, only on RPGPTV. The knowledge that you're acquiring here is absolutely free. Well, you need data if you're watching this on socials and from your phone. But that's it from us. You take care. Stay blessed.